Yeah.
Welcome to our webinar, CRE Legal Issues During the COVID-19 Era. My name is Jennifer Hartigan. I'm one of your hosts today. Please note that this webinar is being recorded and all participant lines are automatically muted during the broadcast. Today's presentation will last up to 45 minutes. If you would like to ask a question during the presentation, please type your question in the Q&A box, and you can see that on the usually on the bottom of your screen, bottom center. Questions will be reviewed and then we will answer them after we discuss each of the questions. But please submit your questions in the Q&A box at any time. And now it's my pleasure to introduce Michael McGinnis, NAIOP New Jersey's CEO. Welcome, Mike.
Thanks, Jennifer, and welcome everyone to our new virtual learning platform here. We're happy to keep you apprised of what's going on and keep you informed.
Michael?
David?
I can't, you stopped talking.
Oh, okay, hold on. Oh my.
I can hear you now.
You can hear me now?
Yep.
Okay. All right, so we're good.
Yep.
So, Jennifer, I just want to thank our sponsors for today's program. And I also would like to, we have many, so we've just take a quick look at that and remember that these sponsors help the organization run its operations. Also, I'd like to make a few announcements for some upcoming events. April 29th, this Wednesday, we'll have the second or third of our screen side chat series. This time on the supply chain. Our featured speaker on Wednesday at 2 o'clock is Ann Strauss-Weeder with the North Jersey Transportation Planning Authority. On May 7th, we have a tri-state COVID-19 webinar that we're putting on collaboratively with New York City, New York State, and the Southeastern Connecticut chapters of NAIOP. We have some very high-level people participating in this, and I encourage you to register for that when that becomes available. September 9th, we are holding that date for our 33rd Annual Commercial Real Estate Awards Gala. We have our fingers crossed that that will turn out perhaps with some modifications at the Palace. Our Golf Classic, again, September 21st, Trump National Bedminster, and last but not least, November 2nd, our President's Awards and Hall of Fame dinner at the Glen Point Marriott in Teaneck. So at this point, without further ado, let me introduce our featured speaker today, David Gordon. He is a partner and shareholder in the commercial real estate and land use environmental groups at Wilentz, Goldman, and Spitzer. He represents developers, owners, users, and other clients in all aspects of complex real estate transactions. David has always been the go-to guy for me whenever I've got a question or I need clarification on some real estate legal issues. So, and David, his firm also, Wilentz, is also a sponsor with NAIOP. So, David, I'd love for you to take over at this point, and I'd like to toss to you the first topic of today, and it's the one that's on a lot of our minds. It has to do with rent relief, and obviously, if you're a landlord, it means one thing. If you're a tenant, it means something else. So, 1st of May is right around the corner, and commercial landlords across the state are waiting to see if their tenants are going to pay their rent or not. What is your sense, David, as to how this rent relief matter is playing out? And what strategies do you think would be most beneficial to landlords caught between making mortgage payments to lenders and tenants unable to pay their rent? David?
Michael, thank you. Thank you very much for inviting me. Jennifer, thanks for all your work in getting this set up. Before I answer your question, Michael, I just want to say hello and thank you to everybody who's joining us today. I hope that you and your families, both your personal families and your professional families, are all well and staying safe. What you'll hear from me today in answer to the few questions that Michael is going to present is not legal advice. What you're going to get from me is the benefit of my 40 some odd years experience as a commercial real estate lawyer, 6 of which were served in-house working for real estate developers. So I've been on both the outside counsel and inside counsel side of the table. My wife will tell you that I'm an optimist. I have never seen a half empty glass, only one that's half full. But I'm also a realist. And what we are all going through today is just the start of an uncertain cycle that's going to have to play out over an extended period of time. A year, 2, who knows? Certainly not me. The length of time that this is going to take is going to be driven by medical and scientific advances and when people really feel safe enough to come back to the economy, because as we all know, consumer spending is a big driver in the economy. And that'll bring me, Michael, into the answer to your question, because we all also know that rents, tenants, and the rents that they pay are the driver for the commercial real estate industry. We can get buildings approved, we can get buildings financed, but if we can't get them leased and if we can't get tenants who are continuing to be able to pay their rent, we're also likely to possibly lose them. We have seen, starting in April, the first round of pleas coming in from tenants looking for rent relief. And what I have seen in terms of response is an acknowledgement on the part of landlords that they have to help. They can't just say no. It just won't work. When this is all over, hopefully those tenants will be there. They may be diminished, but hopefully they will have the ability to sustain themselves and come back. But they can't do that if the landlords don't give them some kind of relief. As one of my clients once told me a long time ago, the landlord can be the cheapest bank in town. And sometimes interest rates like right now are low, so maybe the landlords do have to help. What I'm seeing is that landlords, depending on the particular circumstances, are very willing to grant some kinds of rent relief. In some instances, it's an actual abatement of rent. Rent is forgiven for some period of time. In other instances, it is some kind of deferral of rent. Now, we all know that there are 2 kinds of rent. There are base rents and there's reimbursement of expenses, which are also characterized as additional rent or rent. And the reimbursement of expenses somehow has to be recouped. And what I'm seeing is that tenants are recognizing that, and they're not asking for total abatement or total deferral. They're just asking for some kind of assistance to help them with their cash flow problems. Granting rent deferral or rental abatement then has a domino effect, because many landlords, probably most, have mortgages that have to be paid. So the real issue here for them to look at when they're making a decision as to what they can do to help their tenants is to figure out what they need to sustain themselves. And it really is the same kind of situation. If you're a tenant and you have problems, my advice to you, go to your landlord. Talk to your landlord. Don't make demands. Explain what the situation is, and between the 2 of you, you should be able to work something out. And if you're a landlord and you think you're going to have problems meeting your mortgage obligations, you should go to your lender and have that same conversation. Lenders are not insulated from this. They know exactly what's going on. Whether you tell them or not, they're going to anticipate that you've got tenants walking in the door asking for help. One of the first things that you should do, however, is take a look at your mortgage documents. In most instances, either the mortgage or the loan agreement or the assignment of leases and rents will have a prohibition against amending rents and granting rent abatements without lender consent. I am also seeing among my landlord clients an absolute refusal to allow those loan documents to jeopardize their ability to help their tenants. They're taking the position that I'd rather go in later and ask for forgiveness than go in now and ask for permission, because A, I might not get it, and B, I might not get it in time. Michael said May 1st is rolling around. We've seen a lot of rent relief requests come in, and we will see even more. And the longer that this lockdown situation goes on, the more people we're going to see coming for help. When I suggest to landlords that they look at their loan documents and speak with their lenders, you do have to be very careful of one thing. You have to be careful to go and consult with your lawyer first. Let your lawyer look at your loan documents. And when the lawyer's looking at the loan documents, just don't give them the mortgage or the note or the loan agreement or the assignment of leases and rents. If your loan has a carve-out guarantee or a bad boy guarantee, one of the common triggers for guarantor liability is an admission by the borrower of inability to pay rents or other debts as they become due. So you have to be very careful about what you say, because even an email to your lender saying, I can't make my rent payment next month, or my mortgage payment rather, or I can't make my mortgage payment or my tax or insurance payments next month because of my tenants defaulting on paying rent, could have a very severe adverse result on your guarantor. You want to open that conversation with guys, we're in a difficult situation. I need to talk to you. But before I talk to you, I need to make sure that anything I say is not going to be held against me. It's not going to create a default under my loan documents. And that is where you need to make sure that your lawyer is involved, has looked at the documents and told you what's going on. The other thing that I'm seeing, Michael, is that landlords are going slow. They're not granting relief for long periods of time, a month, maybe two, but telling their tenants, come back to me in 2 months, let's talk again, we'll see where we are.
That makes sense, yeah. Thank you, David. You know, I assume that everybody is familiar with the governor's executive order issued, I guess, last week, April 24th, dealing with residential tenants that they can use if they request it, the landlord is actually required to let them use their security deposit to help pay rent. But that was something that the governor signed a couple days ago. So that really doesn't affect our sector, but it is out there. Okay, thank you. So let's move along to a different topic, David. Force majeure. We've all heard that. We certainly have it at the chapter here. Force majeure provisions in contracts fail to provide protections from losses or cancellations. That was our experience due to the COVID-19 pandemic. What are some of the best practices in negotiating force majeure contract provisions moving forward that may provide better protections post-COVID-19? Do such provisions, do they cover both performance and monetary obligations? David?
Force majeure, Michael, is a contractual outgrowth of the old common law defenses of impossibility of performance or impracticability of performance. And it's found now in part of the boilerplate of almost every contract and every loan agreement, certainly every lease. But it's far from boilerplate. It has become one of the provisions that can be very heavily negotiated during the course of a contract negotiation, and that includes loan documents and leases. Most of the force majeure provisions that I have looked at do not cover pandemics. Many of them do cover the results of governmental actions or inactions. But most of them also say that they do not apply to obligations regarding monetary obligations, payments that are under the lease. So in that instance, it is not going to be particularly helpful. As I said before when I answered your last question, landlords have to be realistic about this. Tenants have to be realistic about this. And in terms of best practices, it's interesting to me that this country, having gone through a series of catastrophic events such as the Spanish flu back in the early 1900s, 9/11, the SARS epidemic, that the issue of pandemics and its overall impact on the economy has not found its way more forcefully into many force majeure agreements, force majeure provisions rather. They also require, most of them, I shouldn't say most, many of them, many force majeure provisions require that the person seeking to invoke force majeure give notice to the other party. And that is something that, again, this is contractually driven on a document by document basis. And you should be very careful if you are being affected in ways that are going to make it impossible or likely to delay your being able to perform under your agreements, that you look at those notice provisions and that you give the notices that are required. To do that, to not do that rather, is the equivalent or could be the equivalent of a waiver. And when you talk about force majeure and you talk about notices, they sort of intertwine because notices really are, for the most part, boilerplate. It's the thing that shows up at the end of the contract that everybody by then is tired of reading and just skips right over it.
Right.
But most of the notice requirements require notice by certified mail, which requires a return receipt, or overnight courier that obtains a signed delivery receipt. Well, guess what? FedEx and UPS are not getting signatures. They haven't for weeks. And I don't know what the post office is doing, but most people don't want to go to the post office and drop these things off and get the receipts stamped the way that they're supposed to have evidence that it was even mailed. That aspect of the contract, the specific notice requirements, I think will certainly get relief from courts if it should ever come to that. And if somebody were to say, you didn't give me the notice because you didn't send it by a carrier that gets a signed receipt, or you didn't send it certified mail. The courts in those instances, I am confident in saying, are going to say, you got the notice? Somebody sent it to you by email? You got it? That's too bad that it didn't go by certified or it didn't go overnight mail.
David, do you think that the legislature can sort of pass a sweeping law that would deal with that situation? That notice, the modernization of the notice provision, if you will?
Yeah, I don't think, Michael, that they're likely to do that. I don't think that it's that pressing an issue. It has become an issue for a lot of us in negotiating contracts where people like to have email as a method of notification, and others resist it because too many email messages get into a spam filter or get clogged or get caught up in an overloaded inbox and never get seen. That's the standard drafting that I see, is you can give a notice by email, but you have to give it by one of the other methods that's provided in the notice provision at the same time.
Mhm.
But I actually think that it's unnecessary. First of all, I don't think it's going to become an issue in litigation. And if it does, as I
Okay.
said, I think the courts are going to actually look to whether they notice in some form was
Sure.
actually.
Okay. All right.
That being said, there's one other thing, Michael, about force majeure that's important for everybody to realize, and that is you have to make a record. You have to keep notes, dates, names, things like that. It's almost the same as trying, if you're in construction, trying to document weather delays. You have to be able to recreate these things if you're going to make, to look to invoke force majeure as a defense to non-performing obligations. And failure to do that will be relied upon by your adversary if it ever comes to that, and say, well, if it was so important, it delayed you. You don't have any records, you don't have any notes, you can't tell me what days you were prevented from doing things. It will come back to haunt you.
Okay, I understand. Okay, thanks, David. That was great. Moving right along.
Mike?
Yes, Jennifer,
There's actually a question.
please.
So why don't we answer this live? If a contractual provision does not provide relief, are there common law remedies?
So the answer to that is there may be. Again, so much of this will eventually come out to depend on the specific language of the contract. So it's very hard to give a very broad-based general answer. But as I said in the beginning of this, there are common law concepts of impossibility of performance and impracticability of performance that are still applicable to all the contracts that we enter into and that we perform. So the answer to your question is there very well may be common law relief, even in the absence of a force majeure provision.
Okay, any other questions at this point? We'll move along. Okay, thanks, David. Moving into a more broad area, David, on insurance issues. Any general wisdom you would like to share is particularly timely now as it relates to business interruption, business continuity, liability insurance that's being confronted by landlords or tenants, and yeah, please.
Well, Michael, if you're like me, your inbox is flooded with articles and emails that are pointing both to force majeure and to loss of rent insurance. Loss of rent insurance is an element of the business expense coverage of a property insurance policy. And a property insurance policy, actually all insurance policies, are contracts. That's all they are. They're contracts between you and the insurance company, and like every other document, they are driven by their specific language. Loss of rent as an element of business expense comes in when there is a loss of use of real property as a result of a covered cause of loss, and rent is abated. So there are a couple of issues here. If the lease does not call for an abatement of rent, then the landlord would not be able to make a claim even if its business interruption loss of rent insurance was applicable to this event. Most of the insurance policies that I have seen require that in order to claim under a business interruption cause of loss, you actually have to have physical damage to the insured premises. Now, there are going to be some very, very interesting theories put forward by the litigators as to what constitutes physical damage and whether or not infection by a virus is in fact physical damage. But that requires that you be able to prove that this premises was in fact contaminated. Not that there was a pandemic in the area that governmental shutdown. There's separate insurance under business loss for things like the substation 2 miles away gets hit by lightning and you lose your electricity and you're shut down. You can insure that. Most policies don't. And there are insurance policies that can be obtained to cover things like governmental closures. So the business interruption insurance, the availability of that to landlords is going to be, number one, questionable, and number two, and I don't mean to sound like I hate the insurance industry, but I'm a little cynical about it because they're not jumping up right away and say, okay, let's go pay this claim. If they think that there's a provision in the policy that they can rely on to avoid paying the claim, they will do that. And by the time this runs through through the courts, through the judicial system, it'll be too late. The money the landlord will have either gone under or lost the building, or actually won't need it anymore. We'll have made a recovery and it'll be nice to have, but it'll take a long time and a lot of money to get. Liability insurance, however, is a different situation. And I see that coming up later in post-recovery than it would now. Because as people go back to work and as business starts to get more back to normal, there may be claims by third parties, whether they're employees against an employer, could be covered by workers' comp, or customers against the supplier, that the product that was delivered in contaminated packaging or by an infected employee. And again, those claims will get litigated. Those claims probably will be covered by liability insurance. It will depend on whether the defendant, the employer or the producer, took reasonable actions in light of everything that was known, the guidelines, the manner in which they do business. Were they reasonable? Did they take reasonable steps to protect the third parties? And again, it's going to come down to an element of proof, and proving that line of contact from the infection and tracing it back to where it came from can be very, very difficult for individuals. Maybe the governments can do it, but it'll be very difficult for individuals to make those successful claims. Good news is if it's covered by liability insurance, it generally will include the cost of defense unless that is part of your deductible or your self-insured retention.
Well, okay. Well, and again, that really gets to the last question, which is all about liability. And as you say, as we get, as things start to dial back a bit toward what we used to know is normal in the workplace, and we start returning to work, what actions, should landlords and businesses be taking prior to the return of the workforce? Is there some sort of guidebook, or is there some SOPs, or and I know a lot of this is in its infancy, it's likely in its infancy, perhaps not, that landlords should be adhering to before letting or welcoming your workforce back to the office. Any wisdom on that subject matter?
Well, Michael, a lot of this is also going to be fact driven. There is no doubt that as we start to reopen our economy and reopen our society, that there's going to be a lot of guidance out there. Some of it will come from the government, some will come from trade associations and other industry groups, and there'll be plenty of things to think about. Some of that guidance will be useful and practical, and some not so much. Avoiding crowds. My office is in a 10-story office building that's serviced by 4 elevators. Right now, the building is essentially empty except for a skeleton force. I think we have 2 or 3 people in our office every day that handle the mail and checks and things like that. We have some messengers coming in and out and running around to pick up packages. But when you walk into that building, there's a sign right on the first floor that says no more than 1 person per elevator. 10-story building. If it's half full, if everybody's working with a half a workforce, how are people going to get up and down from their lobby to their floor with one person in the elevator at a time? So a lot of the guidance, and the guidance will change. And so they may say no more than 2 people or no more than 3 people, but it's going to be very difficult. And I know we're personally, I mean, my office is talking about when we are allowed to come back and start getting out and around and going back to work, come off remote. They're talking about looking at the groups of people that are on each of the 3.5 floors that we occupy, and maybe going on a rotating in the office work schedule, so that on my floor, my real estate team, my extended real estate team would come in on Monday, Wednesday, and Friday this week and work from home on Tuesday and Thursday. And then on next week, we would work from home on Monday, Wednesday, and Friday, and then go in the office on Tuesday and Thursday. It's all going to, a lot of it's going to be driven by the guidance and driven by the practicality of looking at the physical layout and operation of each individual workplace.
I agree. Yeah, it's going to be a difficult learning stage that we're all going to be going through on this. I would like to add to this. I was on a call this morning with the governor's office, and we do these calls regularly during the week. And I'm sure the governor may have already done so, but today was supposed to be the governor was going to lay out the road to recovery principles, and there's really 6 steps that they're looking that have to be in place, I guess, as we reopen the businesses. And one would be a sustained reduction in new cases of infection and hospitalization for like 14 days. Another is testing capacity has to be sufficient. I don't have any details beyond this at this point. Thirdly, contact tracing mechanisms have to be identified in place. Fourthly, we have to, I guess it was addressed in terms of safe places. We have to look at, you know, what does a safe place look like? So whether it be a hospital, a real estate building, what type of practices have to be in place to make it relatively safe. And then, and the more long-term, it would be resilience, you know, economic recovery. What do we have to do for that long-term, you know, resiliency in the economy? So I just wanted to lay that out at this point. So at this point, how about from the attendees? What type of, any questions? There's many of you on the call, on the webinar at this point. For David, while we have David here.
I do see one that's come in, Michael.
Okay.
Which is an inquiry as to what the current case law is on force majeure, where the clause itself would require rent to be paid versus impracticality, impossibility of performance because the company just doesn't have any money. I haven't seen any cases that talk about this exact situation, but you can look at it sort of by analogy. You've got a company that's doing very well, and all of a sudden its business falls off because it made a product that was sold to children and the federal government says it's dangerous, and it was their biggest product. And now they've got no sales, they've got a lot of returns, and have no money to pay rent. Should they be excused even if because there's nothing in their force majeure clause? Should they somehow be excused because they don't have the money? This may not be quite the same, but it's a close analogy. And I don't think that you're going to find anything, and certainly I can't tell you anything because I haven't gone and done the research about how this would play out. The bottom line is, if this company that can't pay the rent but would have to under its lease provision, survives, hopefully it and its landlord will find a way to fix this. Even if they didn't have rent relief up front, hopefully there will be some on the back end, because vacant space doesn't do any good for any landlord.
Very good. Anyone else? Any other questions?
Yes, hello. My name is Sue McGinnis. I'm calling from Mathematica. I'm trying to reach her name, Angela Boston.
Jan, do you have any
more?
questions on your end?
Nope, I don't see any
I'm from Mathematica.
any more questions. So
We're trying to reach Angela.
if anybody else has any other questions that David can elaborate on, please use the Q&A box. Okay.
Oh, okay. And what is the best
I think we,
Here's one.
is this one?
Do you know what the
Do you-
best number is to reach?
You want to read that out, Jen?
Sure.
The question is whether or not the common law remedies that are available in the absence of an applicable force majeure clause are ultimately going to be winners in court. My answer to that question is that if you ever get into that situation and it's gone by that far, there are no winners, period, because litigation takes too long and it's too expensive. So if the tenant, for example, was unable to pay rent and couldn't come to some agreement with the landlord, or the contractor was unable to pay materials and therefore unable to complete construction of the building, and those things couldn't be worked out in some way, the litigation is not going to resolve it ex post facto back to the beginning and put people back where they were. There may be damages, but that's not going to really help both parties. And I don't, other than that, I'm not a litigator, so I can't tell you what I think about those common law remedies, and they're too fact specific to be able to speculate about.
David, there's another question here. Who said anything about unable to pay rent? It's just a tenant saying they can't use the space. Any thoughts there?
No, not really, because we're all in that same boat when our employees are being told to stay home and we're not an essential business. And even the essential businesses, probably a lot of them have more space than they can utilize because they can't get their workers to work in a way that's totally functionally economical. So the tenant may say, I have no use for the space. And the landlord's response is going to be, I understand. Hopefully they can work something out. But the bottom line is, like, frankly, if the tenant is financially responsible, I think that the tenant has an obligation, and because the governor has or had or has on his bill a legislative action that would give the same kind of rent relief to commercial tenants that the residentials have, where they're being told they can't be evicted. I think that the governor, or at least I hope that the governor understands or understood and still understands that to do that is going to have a huge domino effect. If the commercial tenants don't have to pay rent, the commercial landlord can't pay operating expenses, real estate taxes, which come due at the end of this week, insurance clauses, their own mortgages, so that even one or two big tenants in a multi-tenant building could put the building under.
Right, and David, honestly, I think based on our conversations with the governor's staff, I think they get that, and that's why the governor has been not convinced that he should do anything as it relates to commercial tenants. That let the existing practices, rule. The residential tenants are another story, and they did weigh in on that via the executive order. But commercial tenants, I think they are, for the most part, staying off that.
So another question has come in, Michael, about what responsibility do commercial landlords have to give guidance to their tenants regarding safety and hygiene protocols?
Good one.
And my response to that is, in terms of the operation of the tenants' buildings, the tenants' businesses rather, the protocols that the tenant should be using, the landlord has no obligation. The landlord may have obligations to make sure that it operates whatever it's responsible for, whether it's an office building or a shopping center, that it operates those common areas in a way that comports with the safety and hygiene protocols and guidances that are put out by the government. But I think that if a landlord were to try to impose those safety and hygiene protocols on a tenant, and there were to be problems, the landlord is looking to buy itself trouble.
That makes perfect sense. I guess that raises, being a tenant, one wonders about the cleaning services and the cleaning people that come in once you leave the office in the evening. What's being done in on that front.
Well,
so
that's part of what I meant when I said the landlord has got to evaluate its own hygiene and safety protocols.
Yeah.
The actions that it is responsible to take, and that includes cleaning services in office buildings.
Right.
But that is something that comes end of day. The tenant is responsible for doorknobs during the course of the day as people come in and out of its offices. Things like that. I've seen the restaurants in my area where there are takeout actually propping their doors open with in some way so that people don't have to touch the door handles or don't have to push on the door, pull or push on the door to get them open. They all have these plastic protective sheets now hanging in front of the cash registers. So it depends, as I said, it depends on the type of business and the physical layout and what the interaction of the people is that you're trying to protect. Another question just came in: for leases being negotiated or renegotiated, what are you seeing regarding so-called COVID clauses? That is language that covers what should occur between a landlord and a tenant should future shutdowns be required if the virus rebounds. And my answer to that is I haven't seen any of that yet. My clients are too busy trying to cope with the day-to-day operations. We're not seeing a lot of new leases coming in the door in the last several weeks. I think businesses who are looking to lease new space, they're looking to do it for one of two reasons. They either need more and they're worried about whether they really do or really will need more, or they're worried about they need less. And the question is, how much less, or do I need any? So I'm not seeing a tremendous amount of leasing activity in my practice right now.
Sounds right. Anyone else?
All right,
Any other
great.
questions before we wrap up? Well, looks like we've come to the end of this webinar today. I hope everyone has derived some value from this. We look forward to having you join us again on these somewhat regular sessions we'll be doing over the next few weeks, for sure. Stay tuned. Please read your emails, your weekenders. Jennifer, any other closing remarks?
Nope. Thank you so much for joining us. It was really great to have everybody come here on our very first webinar. We are recording today's session and we will make that available either today or tomorrow on our website. But thank you, David. And thank you everybody
David.
for coming.
Yep.
And stay safe.
Thank you, everybody. Stay safe.
Alrighty. Bye now.